Act affects innovation and research. This past September, President Obama signed into law the AIA, the American Invents Act, which was probably the most fundamental changes to the U.S. patent law system in nearly 60 years. So we have here today a distinguished panel of patent lawyers and a professor here from the university to talk about how this changed not just the law, but what it does for if you're an engineer, if you're a businessman, or if you're an entrepreneur. So our panelists today, I'm Brian Pandya. I'm an attorney in Wiley Ryan in Washington, D.C. My practice focuses on patent litigation. The rest of our panelists here today, we have Kyle Elliott from Spence, Fain & Britt in Kansas City, Eric Rakestraw from Senegar Powers in St. Louis, Jason Schwendt from Thompson Coburn, also in St. Louis, Scott Eidson from Armstrong Teasdale in St. Louis, and Dennis Crouch from the law school here at the University of Missouri. Before we get started, I'd just like to thank Mark Kanellis for organizing this conference and putting this program together. I had the opportunity to meet Mark this past summer. Mark and I are both alumni of the Washington Internship for Students in Engineering program. What it is, the WISE program is sponsored by the National Science Foundation, ASME, IEEE, and a handful of other engineering organizations. And each summer it brings about a dozen engineering students, either rising seniors or graduate students, to Washington, D.C. to interact with congressmen, senators, policymakers, to really learn how engineering and science and the law and policy all interact and play a part together. It's a great program, and I encourage everyone here to, if you're a student, to consider the program. If you're in industry or an academic, to try to support the program. It's a great opportunity, and for me, I was in the program about 12 years ago when I was an engineering student at Penn State, and for me, that really galvanized my decision to go to law school and to work in an area where you can work at the intersection of law and technology. After that, I went to the University of Michigan Law School and then clerked on the Eastern District of Texas, which at the time in 2005 was really becoming a hotbed of patent litigation. And you know, a lot of people will say that the number of patent cases and major verdicts out of East Texas was one of the big drivers of the patent reform bill. So you know, let's talk about what's before we dig into the American Invents Act. Talk a little bit about what caused the patent reform legislation to come about. Now, this legislation was something that had been before Congress almost every year going back to the last 6 or 7 years. So why did it finally get done? What finally pushed it over the finish line this year? And I think one of the things that really, the reason that patent reform finally passed Congress this year was something that happened last summer in 2011. So in the span of about 4 months, we saw there was a bidding war reaching into the billions of dollars for a number of patents, and it really put patents on the front page of things like the Wall Street Journal and other mainstream publications. Back in April of 2004, Google submitted a $900 million bid for patents held by a Canadian company called Nortel, a big telecom equipment maker. They were in a bankruptcy sale, and Google bid nearly $1 billion for it. A couple months later, a consortium put together by, they call themselves Rockstar Bid Company. It's Microsoft, Apple, EMC, Ericsson, Sony, RIM, who makes BlackBerry, nearly bid 5 times as much as Google bid for these patents. They bid $4.5 billion. So, I mean, patents at one time, to a lot of people, were something that every big company held. Some companies value them more than others. But to see a company like Google, Apple, Microsoft making these multi-billion-dollar bids, I think really caught the attention of Congress, really caught the attention of the business community, caught the attention of policymakers to see just how valuable this is, and to see that how the system is changing. So a couple weeks after the rock stars upended Google on their quest to buy the Nortel patents, Google made an offer to buy Motorola Mobility. Now, Motorola, of course, as you know, makes some cell phones, but what Google was really getting at was the patents held by Motorola. And so in August of 2011, Google offered $9.4 billion to acquire Motorola. Again, most of the valuation was for their patents before the bid was announced in the end of August for $12.5 billion to acquire 17,000 patents. So, I mean, to show you how much that was valued, Google paid a 63% premium to acquire Motorola and its patents. Now, this, of course, did not happen overnight. There have been a number of other companies that have seen a great run-up in their value because of patents. Companies like Vernet, which holds some patents by SAIC, a government contractor. Companies like InterDigital, Round Rock Research. There's a company in Chicago called Ocean Tomo that runs a very well-known patent auction that had become increasingly busy. And there's a company called Walker Digital tried to bid off a portfolio of several thousand patents. They were seeking $350 million. No one took it, but now Walker Digital has gone out and filed several hundred, maybe even 1,000 lawsuits. So the patent landscape has been changing. Patents have become, I think, increasingly valuable. There's been more patent litigation. So against this backdrop, that's what really drove companies that were, on one hand, wanted to protect their patents, wanted to protect their innovations. On the other hand, felt they were getting harassed by patent litigation by non-practicing entities asserting patents against them. So that brought us to the America Invents Act. The official name is the Leahy-Smith America Invents Act. Senator Leahy from Vermont, Representative Smith from Texas were the two main sponsors. Was signed into law on September 16th, 2011. There were dozens of provisions to the law. Some significant changes, which we're going to talk about today, were we changed from first to invent to first to file patent system. There was a new provision for reviewing patents, expansion of some prior use defenses. So if you had a patent, or if you're accused of infringing a patent, you can now in certain instances argue that you were practicing your invention before the patent was filed. Changes into the way defendants can be brought into a lawsuit. And there were a number of other changes as well, changing best mode requirements. So if you're an inventor, what do you have to disclose in your patent application, and limits on lawsuits and whether you mark your product as patented. So against that backdrop, I'm going to turn it over to Kyle, and he's going to give a little overview of the patent system and talk about some of the specific changes.
Thank you very much, Brian. Is everybody awake? If we put you to sleep yet, I mean, patent law is such an interesting topic. So, let me start off by saying that if you see a car on campus with a KU license plate on the front, that is mine. So please don't key me. I'm actually quite balanced when it comes to my KU-MU rivalry, and I wish you all well in the SEC.
Do you want the tires back?
Yeah, tires and wheels back would also be very good. Brian's correct. They did ask me to do a little bit of an overview, so I'm going to go through an overview of the patent system. If you've got a question, please raise a hand, throw something at me, get our attention. You've got a lot of knowledgeable people up here, so please make it interactive. If you've got a question, please ask us. The first thing I just wanted to do is, what is a patent? And the biggest confusion point I get is that people think a patent grants you a right to do something. It's the exact opposite of that. It grants you the right to exclude somebody else from doing something, whatever your claimed invention is. That claimed invention, there's those numbered paragraphs at the end of a patent. It's kind of like a real estate deed. You read the real estate deed, it says that 30 by 40 Northwest East stuff that only real estate attorneys understand. And all those numbered claims at the back are what we patent attorneys are the only ones that get to understand. And they define that property right, and that's a right to exclude. And I say exclude, and I put it in quotes, and I say but eBay. eBay is a Supreme Court case in which the law changed dramatically. It used to be that once you proved there was an infringement of your patent, you almost immediately got an injunction. That's an order telling the infringer that they have to stop. Now you have to go through and prove what we know to be the 4 standard injunction pieces, which are, just giving me money isn't good enough. There's got to be some irreparable harm. There's got to be a public interest balance, and in addition to that, you've got to show that there's not a great hardship on the defendant if you're going to enjoin them. So in other words, if you're going to shut down their entire business, you've got 10,000 people working for them, there's a big hardship on the defendant there that they may not grant the injunction. What can be patented? This is something else that, as Brian alluded to, is going into a lot of the patent acts these days. The business method is the thing that started this all off in 1996, and methods of doing business right now are not necessarily patentable. You have to, at this point in time, show there's a machine or a transformation taking place. A good example of this, if you will, is an old Supreme Court case where they had a way of taking the data that was taken off of an X-ray and graphically displaying that for a doctor. And so there's no way that the human could process this data, but the transformation into a graphic vehicle that a physician can actually comprehend, a human can comprehend, was seen as a transformation. So no reason to go down all these, but basically the old Supreme Court case says anything under the sun that's made by mankind, that's what's patentable. Okay, I should have asked my question beforehand. Who knows what the term of a patent is? How long is a patent good for? Somebody help me out. Got to keep you awake and get this interactive. Who knows? The panelists are excluded from this. They can't answer this question. They know this. Somebody out there has got to shout out a number. How long is it good for? That would be in the area of copyrights, okay? Would be close for one term. But the patent is good for 20 years from filing, okay? It used to be 17 years from issuance, and it went from 20 years filing, and that's in this point right here. And it's the earliest claim priority. So if you have multiple patents that you filed where you claim priority on them, it goes back to the earliest one. The thing that surprises most people is how long this takes, and it's very frustrating for clients. I know Eric does what we call a prep and pros practice, where he prepares applications and prosecutes them through the patent office, okay? And that process can take years. I had one particular case that was pending in the software arts encryption technology for over 8 years before we got a first response from the patent office. So it's a very frustrating and obviously also very expensive process for the client. And then the term of design patents, which are somewhat more akin to trademarks, is 14 years still from the date of issuance. How do I get a patent? One of the other things, because we're switching from a first to invent to a first to file, and I'll comment on that in detail in a moment, is a lot of people said, well, I don't need to keep an inventor's notebook anymore. You still do. So when you're in the lab and you have employees that are hired to create and invent, it's still very important they keep that inventor's notebook, because that will still be used to be able to prove that they are an inventor. Okay? And disputes can still arise between competing parties over who has actually invented it, or if one derived it, learned from it from the other. And so those inventor's notebooks are still very important. There's no search required. Now, what you need to do is file the patent application before publication. There's 3 barring events under current law. Yes?
Do inventors' notebooks have to be on paper, or can they be electronic?
They can be electronic. There was a time when somebody would have given this, and did somebody have it raised? Did I see a hand over here to respond to that? Okay. There was a time when you wanted it to be like a spiral notebook that pages couldn't come in and out of, and that's still, I think, the traditional one. But as long as you're still going through the steps of writing it out, preserving it, and with the data software we have that can authenticate it, that's not a problem to make it electronic. Okay? Because it's evidence of invention. And you would also, like an inventor's notebook, you would still have it witnessed by somebody who's capable of understanding the technology that you are working in. Okay? Good question. There are 3 barring events under current law of public use. Okay? A public use can be if it's a lawnmower attachment that's your invention, and you mow the front yard, okay? Mowing the front yard with your attachment, that can be a public use. The Supreme Court case on this is an old one that's actually kind of fun. Victorian era case, and the invention is a woman's undergarment, okay? And the garment manufacturer gives it to his fiancée, and she wears it out in public. The joke is, of course, in the Victorian era, even he didn't get to see it because she's only his fiancée. But that's still a public use, because she wore that out in public. Nobody could see it. For us, it's more like a manufacturing method, okay, that nobody can see or tell, and you use that and sell the product. That would be a public use of it. There's an offer for sale. Commercialization is the second one, and it is just an offer for sale. It doesn't have to be a completed sale. It's an offer for sale. And the other is a public disclosure, and that can be you told too many friends at a party. Everybody, it's come back a little bit, but do you remember the Rubik's Cube? Big litigation over whether the use of the Rubik's Cube at a party was a public use or not. My vote on that one, they saved him. I think it was bad law. They saved him. I think it was public use, but he was passing it around to friends to use as a party. So you want to do that before any of those three events. You want to get it on file before any of those three events to preserve your foreign rights. Okay? Because the rest of the world, excluding Canada and Mexico under the NAFTA legislation, do not have any type of grace period like we have here. Here in the U.S., under current law, you have 1 year from the occurrence of those events to get that application on file. Okay? And that's going to change effective March 16th of 2013. Now here's what happens under the new law as a possibility, and that's publish as soon as possible, and you still have to file within 1 year to preclude later company filings. And I've got a little example later on that I think will demonstrate that, so I won't say more about it here. And then the next part of it is, remember, you wait that, in this one poor guy's case, 9 years to get that first office action, okay, first action by it. You've got to convince that examiner that there is something patentable, okay? I want to also touch very briefly on trade secrets, because when I get into the prior use defense, this is really the first time in the statutes where we have favored trade secrets over patent protection, where there's actually some encouragement for you if you decide to keep something a trade secret and not patent it, there's a statutory benefit for you. And this slide, I hate doing long slides like this, okay, because I'm obviously not going to read it to you. You probably don't want to read it. Just remember it has to have value and it has to be secret. Those are your two key terms for your trade secret. It has to have value and it has to be secret. How do I get a trade secret? Education of employees, agreements with employees, vendors, contractors, everybody that comes in and out of the plant is escorted all the time, security, limited access, only those that need to know it, okay? Part of that security thing, or part of that secret thing is it's not something that can be reverse engineered. Now, I want to take a poll, I like doing this, okay? How many of you really think that Pepsi can't reproduce the Coca-Cola formula? How many of you think that? Come on. Who thinks that the Coke formula cannot be reproduced? I'm with you. I think if Pepsi wanted to, they could reproduce it, anybody could, but why would Pepsi want to make Coca-Cola? So, all right, first to file is what the system is called, first to file. But the first to disclose knocks out a later filing, okay? So here's my little example. A invents it, followed by B's invention, okay? B then discloses it, later A files and B files. Okay? Under the current system, A, meeting all the conditions, would be the recipient of the patent. All right? Under the current system, I'll take a poll here, under the new system, the first to file system, who do you think gets the patent, A or B?
B.
Got B guesses, and you are correct. And I've only done this a couple of times and nobody gets it wrong. I keep thinking you'll say A because it shows A was actually the first to file, right? The reason why A doesn't get it first is because B's disclosure is going to block A's filing under the statute, but B has his own personal grace period that if he files within 1 year of his disclosure, he still gets the patent. Yes?
What's the definition of a disclosure?
That is up for interpretation. Okay, according to legislative history, it should be those three events. And I can't remember which senator it was that was asked the question. Dennis, you may know this. But one of them was asked that question on the floor, and he said it's basically the public use, the things that would qualify it to be prior art.
So yeah, so it's a suggestion that it's a public disclosure, but that's all we have. But there is kind of 100 years or more of cases interpreting this type of thing. And so we think probably it'll be the same things that are currently disclosed, things that are currently called disclosures will still be the same types of disclosures.
Yeah, and there is legislative history to that effect, yeah.
But then won't A go back to court and invalidate B's patent?
Not under these facts, okay? You'd have to have something else take place. He could, okay, if B ends up suing A, okay, A, and then we'll get into prior use in a second. If A has other prior art, things that have been out in the public before, yeah, he has a defense that the patent that B obtained was invalid. But this disclosure by B, that won't be a basis for his invalidity argument. It's going to have to be something else. Okay? Good questions. Other questions? Comments by the panelists? All right. Okay, now let's let me go through and change the facts a little bit. Okay? If B doesn't disclose, let's get rid of that fact. If B doesn't disclose, who gets the patent? A. You got it. All right? If A discloses here at Y, what happens? What do you think? Either one of them get it, they both knocked out. What do you think if A discloses at Y?
Are you putting B discloses back in?
Yeah, B discloses is back in. Thanks for the point of clarification. B discloses, and then A discloses here at Y. Hey, I actually got you all thinking. This is
It'll
good.
be first, and if B goes in first. The question I have is, what if C discloses? What if an unintentional disclosure happens wasn't the intention of B, but it is disclosed? Then does B benefit from that unintentional disclosure?
If C got the invention, if his information came from B, yes, B gets the benefit of it. If B is out in California and B doesn't know, or excuse me, C gets it from B, then it's okay. If C's out in California, C discloses it, C never talked to B or A, then it bars both of them. Okay? Yes?
So it doesn't matter who invents the product first. It's about who discloses it first.
Yeah, it's about who discloses it first, okay? If there's a disclosure. In the absence of disclosure, it's who files it first, okay? And help me out, guys, because this is, I mean, we've all spent some time noodling over this, I know. Yes?
I have a question which is directed to this whole act, which is, but on this specific point, is why? You know, why?
Okay, I'll take a stab at that, and that's actually a good panel question. I think I ought to sit down and we'll roll down that one. I'm a little bit jaded when it comes to these things, and what I think is that we are going to harmonize with the rest of the world, which would be a true first-to-file system. But frankly, the university lobbyists did a wonderful, wonderful job of pressing into this act and getting this personalized disclosure in there. And when we go to the prior use defense, you're going to see another area where the university, the collegial lobbyists, got some things in there. Because what do you do as a professor? Publish or perish. Okay, so that's what we do. We publish. We get information out of there. And so the worry is that if we just change to a straight first-to-file system, the universities are really going to be damaged. And I think there's truth to this. Well, I'm jaded, but I do think there's truth behind it. That the universities would be overly damaged and disadvantaged because of that switch to a first-to-file system. So you put in this personalized publication. Other thoughts?
I agree with basically with what Kyle said. I mean, this legislation initially came out and it was directed towards going to a very clean first-to-file system. That's it. And that would have harmonized the U.S. with what every other major patent office in the world does. And that would, in my opinion, there's a lot of reasons that would be a better system. You don't have to dig into things like who, disclosed something outside the patent office, messy factual situations, which is what we're trying to avoid with the system we have now. Like we have to dig into who invented first and literally go back and compare inventors' notebooks and have testimony, and it turns into a big mess. It gets very expensive and takes a long time. But through the legislative process, this is sort of what we arrived up, which is a compromise that, as so often happens, doesn't really hit any of the major points we wanted to hit, but everyone can sort of settle. Yeah,
it's a settlement.
I think there's one additional issue. I think this harmonization is right that every other country in the world has a first-to-file system, and there's a second element to it. That one driver that Brian mentioned for this reform is that there were lots of companies getting sued for patent infringement, and so there was a substantial amount of lobbying to in a sense weaken patent rights so that it's easier for those companies to do their business without worrying about patents. And one element of this change is that it does implicitly make it a little easier to invalidate patents. Because with a first-to-invent system, a patent holder claims priority back to their invention date. And we only look to see, was it new as of the date of invention? And now we're moving down that timeline. Under the new system, we say, was it new as of the point they filed the application? right? And anybody knows that's often the date from invention to filing, right, may well be over a year of time. And during that period, if you're in kind of a hot area of science or technology development, right, it's likely that other prior art will be created in that year and make it possible to invalidate that patent. And so I think that is a result and an intentional result upon based on some of the lobbying that was going on in Congress.
Any other comments from the panel, and I'll pick it back up. All right. Last question that I have here is, what if A discloses at point X? Who gets the patent? This is the easy one. A. Yeah, A discloses first. We've already discussed it. It still has to be within 1 year from X to when A files. Okay. Prior use defense.
Question.
Oh, yes.
One other question about your AB thing there.
Yeah.
Does that public disclosure still knock out the foreigns?
Yes. Yeah. The slide, let's see here. Ah, rats. I should have just. You can tell I'm not a PowerPoint professional, to say the least. Okay. This right here, file the application before publication, public use, commercialization to preserve foreign rights. That's right. Because if you publish it, that's going to knock out your foreign rights. And that's another change that I won't steal Eric's thunder. I bet he's going to get into what happens with foreign prior art. Okay, other questions? A prior use defense. Has to be a commercial use. Okay? What this basically says is, if you are using this before, okay, the guy patents it, your competitor patents it, you get to keep using it. Okay? So you've got some secret use. It's a method of building something that people can't discern, is a good example. And so you get to keep doing that under certain conditions. Before I go on to the conditions, it says commercial use. Well, what about research? What do you think? Should research be covered? If I'm using it for research purposes ahead of time, should I get to continue my research, or should I have to stop?
I hope the answer is yes.
The answer is yes. The answer is yes. And it's there's two kind of things that qualify for commercial use that you wouldn't think of as being commercial use. One's a regulatory review. So if it's a new drug, for example, and I've got to get out there and get it ready for regulation, that's going to qualify it as commercial use. And then also research by a nonprofit laboratory. The thing about it is, though, it's going to have to stay nonprofit. Okay, so you won't be able to roll it out, take it to your tech transfer, and then start licensing somebody else. It's going to have to stay nonprofit. Okay, that commercial use has to start more than 1 year before, okay, the earlier of the filing date of the application or that inventor's public disclosure of it. Okay, so it's got to be 1 year ahead of time. If you start it within that year, it's not going to work. Part of the policy here, I think, is, and Dennis is way ahead of me on this scale, is that you want to make sure that what you're doing is not punishing somebody that has established a business. So they build a plant, they invest $10 million to start manufacturing something. We're saying we don't want to shut that person down, okay? But if it's within a year, they probably haven't invested that much, so we're going to go ahead and allow them to shut them down. Yeah.
Yeah, I think really, what this is getting at is, it's when you have companies like Apple, for example, you have like my iPhone right here, there's probably 1,000 patents that this could allegedly infringe. And so what happened was you had a lot of consumer electronic companies were getting sued by non-practicing entities. They had no idea these patents were out here. So what this is, it's almost a safe harbor or a way to, as Dennis and Kyle mentioned, the patent reform was a way to slightly alter the balance between patent holders, people that are accused of infringing patents, and what this prior use defense is a way for technology companies that are getting sued for patents that they never heard of, that they have no idea that something minor component in their product is allegedly infringing this patent. This is a way for them to say that, well, we independently developed this software, developed this chipset, developed this hardware a year before we were selling our product, long before this guy came and filed their patent application. So I think this is really an example of how the American Invents Act changed the balance between patent holders and patent users or patent infringers.
Other comments from the panel? Questions? Okay.
Go ahead.
Yeah, go ahead.
I mean, doesn't that go against the basic fundamental theory of patents of encouraging public disclosure of inventions?
Yes, and that's why I put the trade secrets up there. This is the first time we've statutorily favored a trade secret decision from somebody as opposed to a disclosure for patent purposes.
I think they kind of opened that door a little bit when they had done this with business methods.
Yeah, the prior act had the business methods.
And so there was already a little bit of a sliver of this, and they found that it really wasn't that big a deal. It didn't really, eke away that much of patent rights. So this, well, we'll go ahead and expand it. It worked out well with that. Why don't we go ahead and expand it? We'll see how it plays out, but you're absolutely right that it is definitely chipping away at what a patent is supposed to be.
Excellent point. Yes?
Now, does prior use defense also occur if the patent that you could be infringing upon had been filed in play before it was secretly used?
Yeah, you've got, your use has to begin, your commercial use has to begin more than 1 year before the filing of the patent application or a disclosure by the inventor. Okay, so it will not protect you from a subsequent use. That answer your question?
Well, I was wondering, it's to help protect your intellectual property if there's something else out there before you go to file, right?
Yeah, well, so the idea is, so with Brian's notion of Apple, right? If Apple began using some process in its factory, right? Maybe they began using that 2 years ago, and then someone else independently came up with the idea for the same process and later patented it. Then that later patent, right? That holder of that later patent would not be able to go and sue Apple for what they had already been doing, and that is a change in the law, because under the old law, you could go and sue Apple. And that's why, right, because it used to be that patents were clearly favored over trade secret uses. And so that even if somebody else had been using it beforehand, you could sue them on that use. Right now, the big caveat with all this, right, most likely, right, most prior uses that are ever going to be sued on will, right, when Apple makes some device, they're also selling it publicly. Right, and as soon as it's sold publicly, that becomes prior art that then invalidates the patent. So this only comes up if somebody's using it commercially but secretly before the filing. So,
excellent explanation. Did that get it?
Yeah.
Perfect. Leave it to the law professor to be able to explain.
In your explanation, if Apple was using this secret art only 6 months before it was filed, they still sue?
So I believe that Kyle's the answer is no, right?
Correct. It would not be a defense.
It would not be a defense.
It has to be a year.
It has to be a year beforehand. Yeah.
Yep. And the thing about this is you've got to show it by clear and convincing evidence. It's an elevated standard. I won't get into that. It's also a very personal defense. If you cannot transfer this to anyone except via the sale of the whole business or the entire line of the business. Okay. Now, expansion is permissible. Your volume can change. Okay, volume can change, but the site can't. You can't change sites, and there's limits on, when that transfer would take place and what you can do. It's also, this is not something where C, the example we gave earlier, C didn't come up with this. The prior user C, he didn't get it from B, the patentee. Okay, he did come up with it on his own. If he derived it from the patent holder, then that doesn't count for the defense. Okay. Let's see, and I really think that's basically it for that. And let me go into the very quick exception. And everybody, this is going to be forever memorialized. So this right here, you could read this as being correct, but it's actually wrong. Thanks to Dennis, I now know what the answer to this is. There is an exception to this, and that is for a university. If a university or tech transfer is the one that holds the patent, you can cut off that prior use defense. Okay, so again, the universities had a good lobbying effort to get a special exception in there for the universities. And then there's an exception to the university exception, which we now know applies that if there's some federal statute that says this particular research or this patent couldn't have been funded by the federal government, okay, then it's not going to be something where the university can take advantage of that. Okay, and this was effective on 9/16/11 is when the prior use defense was made effective. And Eric, I'm ready for you.
All right. I think through our discussion, we've covered a lot of this. So what I'm going to try to do here is sort of wrap up everything that Kyle talked about with a nice bow, and then try to confuse you more by poking some holes in what I think are some common conceptions of the first inventor to file provisions. So this is a really dense slide, and that's probably because patent law is itself very dense, so you can take that away from it. But if there's one thing that I tried to visually convey here, it's that the American Invents Act actually cleaned up and simplified the law at least a little bit. Okay. Now the biggest change, first to invent, our old date used to be when you actually invented your invention. Now the only date that matters is when you filed it or disclosed, which we'll get to in a minute. Okay. But there are some other things that got cleared up. One of them is we had this sort of archaic distinction between different categories of things that can be prior art and where they occurred. Okay, so if something was patented or published in a sort of a written publication anywhere in the world, that was good to be prior art. But we had this distinction that if it was, say, a public use or an offer for sale, that had to occur in the U.S. And Dennis, you can correct me if I'm wrong, but I think this came from the original, the prior patent statute that was passed in the 1950s. And you can kind of see where that was coming from. The fact that in the 1950s someone might have been using something in China, well, maybe it wasn't really fair to hold that as prior art against an inventor in the U.S. because it wouldn't have been commonly known here. But now in 2012, the world has shrunk, and we've gotten rid of all these geographic distinctions. So something gets patented, it's described in a printed publication, it's in public use, it's on sale, or any way otherwise available to the public, that's prior art regardless of where it occurs in the world, as long as it's before your filing date. So the public disclosure exception that Kyle talked about, more precisely, it's a 1-year grace period for disclosure by the inventor. Okay, and that prevents any subsequent third-party disclosure from being prior art. So what a lot of people do is they look at this and they say, instead of being a race to the patent office, isn't this really just a race to the publisher, right? Because certainly, in a lot of cases, publishing or just publicly disclosing or offering to sell your invention, that's a lot faster and easier than getting a patent application put together and completed. So a lot of people say, okay, why wouldn't you just do that first? Why wouldn't you say, I'm going to go ahead and disclose my invention, that buys me a year, then I can file, say in the U.S. a provisional application that buys me another year, and then then my patent term will start the clock ticking. Well, one major reason you don't want to do that is foreign rights. Okay, the rest of the world, let's say Europe in particular, has a strict novelty standard. They do not have this 1-year disclosure provision. So if you care at all about filing internationally, you really can't disclose before you file, period. Because it works in the U.S., but it doesn't work anywhere else. And that's one way that the American Invents Act failed to really achieve the initial goal of harmonization. But the other big question that I have, and I actually want to pose this one to the panel, is whether even if you don't care about foreign filing, it's wise to rely on the disclosure provision, okay? And where I'm coming from here is that we have a requirement to be issued a patent. Not only that you're sort of novel and inventive over what's out there in the prior art, but that your disclosure is enabling. Okay, it has to enable another person who's skilled in the art to essentially reproduce your invention without undue effort and experimentation on their own part. Okay. Well, we know what that means in the context of the patent application because you have a big written description that you can look to and sort of pick apart and see, well, yeah, this does tell you how to make this or perform this process or what have you. But what does that mean in the context of, say, offering to sell something? Or let's use the Rubik's Cube example. Okay, if someone has a Rubik's Cube and they disclose it in their party to other people that have it, well, does that really support a later application with claims to a Rubik's Cube? I mean, how can you really say if they didn't totally explain to everyone at the party exactly how the Rubik's Cube works and how to make it and what the theory is behind it? Is that really going to hold up in court to support a later claim to a Rubik's Cube? I don't know, what do you guys think? I mean, about is it wise to rely on the disclosure provision for that reason?
I think there's definitely issues with that, especially since in most prosecutions you're going to see the claim scope change from especially from when you're initially envisioning your claim scope, or maybe even your first drafts or whatever, to where to issuance, your claim scope is going to change dramatically, and your disclosure has to enable and describe all of that from the beginning. So if you're relying on a disclosure, especially if you're talking about a public use or something like that, where it's not a written description of some sort, if you're relying on that to enable a full claim scope that you may later get, which is going to be guided by what's in the marketplace, what your competitors are doing, what you may be trying to capture at a later date, you can really end up in some trouble if you're not fully enabled there.
But even, to me, even if it is a written, let's say a publication for a scientific journal, those are written in such a different way than patent applications. When you publish for a journal, you're sort of very deferential. You give credit to everyone who came before you. You're standing on the shoulders of giants. You only came up with this sort of really narrow, meager, humble contribution to the art, and you do the exact opposite in a patent application in every possible way. So even a full journal article may not have anywhere near the level of disclosure of this type that you really need to have.
Eric, I think the best practices would if someone's going to publish something and you wanted to rely on this publication date, you would really want to go and have one of you guys fully review that what's going to be published, and most likely draft up kind of a full patent application that then at the same time, simultaneous with the scientific journal getting published, the tech transfer office or the company would also release publication of this patent application, so that those could combine together to fully disclose what's going on. Of course, in reality, that's not going to happen in reality. That folks are going to think of this disclosure as essentially a poor man's patent application in a sense, and that's where the failure is going to come. Right now, I do think some companies are going to rely on this to their benefit, because what you can get here, if you have an invention that you might say has a long tail of viability, where most of the value you think is going to come 15 or 20 years out from now, where that's where your royalties are coming from, and there's no sale, there's no market right now for it, well, this early disclosure doesn't trigger that 20-year timeline, And so you could file this early disclosure, and then you could follow that up with a provisional patent application, And then you've got, and then you follow that up another year later with this non-provisional. So then you have 22 years in terms of patent term, and so that is, And so there will be some sophisticated companies that follow that mechanism in order to extend their patent term. But that's going to be very few.
It's industry specific. If you're in the pharmaceutical industry, then this might be a good idea where you count your revenues, your patent revenues by the day of your patent. If you're in the software industry, it's still probably to your benefit to get on file right away when software electronics have a much shorter useful lifespan for the invention.
And definitely the important thing to consider here is that when you're going to be looking at these disclosures into whether or not they fully enable or whether or not they actually describe, it's going to be in the context of litigation. That's when this is going to happen. So you're going to be spending, tons of money at that time to invalidate the patent, and you're going to be they're going to be pouring over this disclosure, whatever it is, whether it is a scientific journal article or a testimony from people who were at this dinner party who saw this thing demonstrated. That's when you're going to be having this disclosure really being vetted. And that's when you're going to have difficulty. I think you're really going to have, I think you're right, I think it's going to be difficult to show full enablement and full written description for everything that you've later claimed. I think if you're savvy, you're right, you can use it as a poor man's patent publication, but again, you've got to coordinate that with patent counsel to make sure that you've really enabled and described everything that you hope to claim.
Right. So to sort of tie that up, I mean, in terms of, do these changes, in terms of going from first inventor gets, to file to first to file, from first invent to first to file, does that change your filing strategy? I don't think it should, because I don't think that you should really rely on this. I still think that you should be trying to get something on file as quickly as possible. And to be honest, that's what most people should have been doing under the old and current law pre-AIA. Thinking that you're going to rely.
No, I'm sorry. I think what it does do is, though, and maybe you can comment on this, it puts a lot more pressure on prosecution counsel.
Absolutely.
Gone are the days where you can get a disclosure and sit on it for 3 to 5 months. I mean,
right.
I've talked to several clients who are basically saying, when I give you a disclosure, I want to see a draft in 2 weeks, and they want very fast turnaround. And so I think on the practice end for a prosecution professional, that is going to make a huge difference in the way practice is done.
It will, but even under the current law, you should not have been relying on being first to invent, because yes, at the end, might you have be able to succeed? Yeah, but think about what you have to go through to get there. If someone else files before you, there's a presumption that they invented before you. So you have to initiate what's called an interference proceeding, which is an extremely sort of arcane and archaic process. It's very expensive, very drawn out, and you have to sort of overcome some burdens and prove that you were actually the first to invent and that you should be entitled to the application. It's possible, you can do it. I've been involved in ones that have been successful, but it's not fun. It's not, I mean,
it's expensive.
It's very expensive, and so the optimal strategy now is still to be the first one to file. So I don't think this really changes what you should be doing as far as your filing strategy. All right, Jason.
All right, so I am primarily a patent litigator. So my focus is going to be on how to kill patents. So one of the first things that I want to look at is, and this is one of the things that most excited fellow litigators when the American Invents Act came out, is the changes to the Joinder law. In the past, and when I talk about Joinder law, what I'm talking about is when you have a lawsuit. Patent holder sues supposed infringers, they bring them together in a lawsuit. And in the past, the way this would work, pre-American Invents Act, you would have large groups of co-defendants. You would have one patent holder who goes out and sues everyone that they can find who is infringing the patent. You could have lawsuits with 20, 40, I've even seen them with hundreds of defendants in a single lawsuit. So this is all in one lawsuit, hundreds of defendants, 20, even if you're talking 20 defendants. That's a big logistical nightmare in terms of coordinating all those efforts. Now, we're not just talking about co-defendants who would be in the same industry. Apple, or if you're out there and you want to sue Apple, you're not just going to sue Apple, Microsoft, and those. You're going to sue other industries that are involved. So you may have people from the consumer electronics industry, you may have people from banking, you may have people from the automotive industry, you may have people who are online retailers, all in the same lawsuit. So their technologies vary incredibly, and they're all together in one lawsuit. That makes it also difficult for when you're presenting any of your arguments, whether you're a plaintiff or a defendant, when you're presenting your story to a jury who has to understand and comprehend the nuances and technical details of any particular industry, and now they've got to do it for multiple industries. Well, that makes things very, very difficult to understand. Typically, the way it works in the pre-AIA day, most of your litigation was being brought in the Eastern District of Texas. As Brian talked about before, that was the hotbed of patent litigation. And the Eastern District of Texas had initially a reputation of being very plaintiff-friendly. That has changed somewhat, but I think it still is a very plaintiff-friendly venue. So your patent holders would bring all of your suits in the Eastern District of Texas. In addition, because they sued a number of different defendants, they would pick and choose their defendants and the location where those defendants were from to make it very difficult to transfer the case out of Texas. The way it would work is you would sue a defendant in Seattle, a defendant in Northern California, a defendant in Arizona, a defendant in Iowa, a defendant in Chicago, a defendant in Florida, and a defendant in New York. Put them all in the same case, and then, and you might throw in a defendant who's located in Austin, Texas. You bring the case in the Eastern District of Texas, And then when any of those defendants say, look, I sold some products in Texas, but I do my business in Chicago, all my witnesses are located in Chicago, all my documents are located in Chicago, everything that has to do with this alleged infringement is in Chicago, move the case to Chicago. The court will look at it and go, yeah, but I've got all these other defendants from California and Florida and New York, and there's no real central place for me to move this. Why don't we just leave it here in Texas? And so the case would stay in Texas. So you had these defendants who were from different locations where they were truly had most of their documents, most of their information, most of their witnesses. Now they have to pay money to travel to Texas to do this. You have to hire local counsel down there. You're not in your home court. If you're a major corporation, you're Microsoft, you're going to get a better deal generally from a jury in Washington State than you are in the Eastern District of Texas. So the difficulty to transfer, this created a lot of conflict between Texas and the Federal Circuit, the Court of Appeals for the Federal Circuit that handles patent cases. A lot of conflict there. There's a lot of conflict between lower courts and appeals courts about this because defendants felt that they were being disadvantaged by having to litigate in a forum where they had no real connection. So what happens with the American Invents Act? Well, the change in the law is that you can no longer join or consolidate defendants based solely on an allegation that they are infringing the same patent. And this is a big deal in terms of practice, and that the fact that they clarified this. Arguably, this was the law in the past, that you weren't necessarily supposed to be able to join disparate defendants into a single litigation just because they were infringing the same patent. In the past, plaintiffs would make the arguments that, yeah, but if you're infringing the same patent, you're probably using the same or similar technology, so we'll decide all those at once. This clarifies and says that cannot be the sole reason for joining your defendants together. Now, the gist of this is that it applies primarily to you cannot join them for trial. The way this is playing out, that means that if you're going to have multiple defendants that you were suing for infringement, you are going to have a series of trials. You'll have defendant 1 tried, then you'll have defendant 2, then you'll have defendant 3. That's for the trials. That does not mean that you won't have a common and consolidated discovery or litigation period leading up to trial. So you'd still have the same, I don't know how familiar you are with Markman hearings, or the claim construction process. That's where there's actually a process in court where the court determines what the words of the patent mean and exactly what you're covering. It's a very important part of a patent litigation. It's probably arguably the most important part of patent litigation. That hearing decides what the patent means. They will still consolidate and make sure they only have to make that determination once. We're only going to tell you what this patent means once, and that applies for all of your cases. But when you get to trial, you will all go to trial one at a time. In theory, the fact that you are suing individual defendants is supposed to make it easier to transfer, or it's a thought that it could make it easier to transfer. If you are suing Microsoft and American Airlines and Amazon in a single, and you have to sue them all individually, well, Microsoft can say, as soon as its suit's filed, you can file a motion to transfer and say, look, I got no connection with Texas, all my major witnesses are in Washington, get me back there. And when you do the analysis of a transfer, it should work out, in theory, better and easier for you to transfer your case back to Washington if you're Microsoft. It's supposed to work that way. There is the aspects of the transfer analysis, particularly judicial economy, where courts may still decide that it's still an advantage to have all of the pretrial take place in one location. Have one court do the Markman hearing, construe the claims, and make sure that it's consistent. So this has not really played out in terms of, we haven't had a whole lot of time to evaluate how this is working, but it's supposed to have changed this sort of transfer imbalance and make it a little bit easier to transfer. We're still waiting to see how that plays out. So, is multi-defendant litigation dead? Well, not really. It's kind of still evolving. Currently, the trend that I'm seeing in my practice, and anyone on the panel, please feel free to chime in with this. What I'm seeing with my practice is that there are more suits that are being filed in Delaware or California or in states where your defendants are located. They're actually going to where the defendants are locating. So you're getting suits filed in your home jurisdiction as opposed to all the suits being filed in Texas. If anybody disagrees or if anybody sees anything different, please chime in. But I'm kind of seeing where they're going to where the defendants are. Delaware is a big choice because the majority of companies are incorporated under Delaware law because of the tax advantages. And so that's a nice central location to get a whole bunch of defendants sued at once. Defendants, though, what I'm seeing in these litigations is that they're still taking advantage of a consolidated pretrial. There are actually advantages to defendants for having a whole bunch of defendants in a case, especially for discovery. You can cut your costs if you're having to do prior art searching or looking for references that are going to invalidate a patent. If everybody can pool their money together, you can all look for prior art. You can all kind of evaluate that at once. You can share not only your money in terms of looking for those things, but you can also pool the labor in terms of actually going through and analyzing whether or not you're invalidating the patent. Defendants are still taking advantage of this. This is still something that's occurring. So even though you get sued in Delaware and there's multiple defendants who are sued, but all in individual cases, what's happening is that the courts are, in some cases, not even consolidating the actions into one particular action. They're just de facto consolidating it. They're setting them all on the same schedule. They're setting scheduling hearings and hearings on the same date. And they're basically just proceeding as if the case is consolidated, even though they are not. And then they're waiting to see what happens and whether or not you actually have trials that occur. Now, patent litigation is no different than any other litigation. The vast, vast, vast majority of cases settle, well over 90%. So we still do not have many trials that are occurring on cases that were filed after the American Invents Act took place. So we don't have a lot of information in terms of how the change in Joinder has affected the way in which trials are actually occurring. There's some thought that it may actually decrease settlement pressure on defendants, because what you'll do, especially if you find out how the order in which the cases are set for trial, if your case is going to be set number 2 or 3 in line for trial, the thinking is, why would you ever settle until you saw what case number 1 or 2 did? If case number 1 invalidates the patent, defendant number 2 and 3 don't have a trial, they're done, they don't have anything to do. If you want to wait and see what happens, you don't face any liability in that. They're going to be potentially invalidating the patent, so you wait and see what happens.
And Jason, what do you think about the possibility of judges kind of phasing out the trial a little bit, and when you've got multi-defendants, in 5 different suits, having an invalidity trial prior to a trial on the merits? Because I don't know if a federal judge is going to give somebody 5 cracks at an apple to invalidate a patent. I know if I'm a plaintiff or a patent troll, I'm certainly going to argue that you shouldn't get 5 cracks at it.
No, and that's a very good point. Yeah, I think what we're going to see is that since we haven't had many of these cases proceed past really Markman in terms of timing-wise, I think we're going to see some innovative approaches to make sure, exactly as you said, that you're not getting 5, 6 different cracks at invalidity, that you're going to have one invalidity sort of hearing of some sort where everybody's combined. But does that, if you have a combined hearing, is that a trial? And because the statute specifically says you cannot consolidate these things for trial. So if you're having a trial on invalidity, there may be problems there. It may be handled in summary judgment, where you have everybody is required to file your invalidity summary judgment motions on a particular day. Court can consider all of them, and then those issues are out. I don't know. Yeah. But it's a very good point, because courts are not going to want, and plaintiffs are not going to stand for, having 5 bites at invalidity, where the first trial goes and they take their shot at the patent. If they win, great. If they lose, then number 2 goes and they take their shot at the patent. That's just not going to play out, and this is still evolving. We'll have to wait and see how this plays out. Any questions on Joinder? I mentioned the effects on settlement. So the other thing I wanted to talk about is the changes in marking law. One of the things that kind of developed right before the American Invents Act was passed was the kind of an onslaught of patent mismarking lawsuits that were filed. And these were cases where a company was manufacturing a product. One of the most famous ones was Solo, the company that makes little Solo cups. I'm sure college students are familiar with red plastic cups. So there are a number of different patents which apply to those cups. And in order to get your full patent damages, what you're required to do is you're supposed to mark your products. So there would be little markings, and you'll see them on products. You know, you can go and look at them now. You'll see that you've got markings where they'll put the patent number on the product. Well, what happened was Solo would be marking its cups, and they'd put all these patent numbers on it, and there'd be 4 or 5 patents on there. Well, that's an actual machinery and a die that they would have to change, you know, in order to make that new marking on there. Well, one of the patents would suddenly expire. It was allowed to lapse, so it was no longer in effect, but they were still marking the cup with that patent number. Well, technically that's patent mismarking. You are not allowed to mark a product that you're selling as being patented if it is not patented. So they were bringing suits, plaintiffs were going on and bringing suits, and they were suing these companies for mismarking their products. Well, the statute allowed for damages for each instance of mismarking. Well, Solo, as again, I'm sure college students are aware, sells a lot of red plastic cups. And so every one of those cups, every one of those sales implied damages. So you were getting these suits brought by someone who had, you know, if you're talking about the balance of costs in a litigation, if I'm a consumer and I bring a suit because you put the wrong marking number on your patent, on your cup, I have no costs whatsoever. I make my demand, I file my complaint, I'm done. There's nothing on my end. Everything is on the defendant's end. They have to defend it, they have to show what's going on, they have to investigate it, and then they face liability for each and every one of those mismarkings. This change in the marking law was to address that situation. And basically what they've done is they've killed the false marking suits. Marking with an expired patent is no longer actionable. They're gone, dead. As of the passing of the American Invents Act, those suits are gone. The only parties who can now seek damages for false marking are the government and any persons who are suffering competitive injury. Now, as a plaintiff, if you want to bring one of these suits, you have to show how you were competitively injured by that mismarking. It's a much more difficult standard. You're now going to have to put something into this case. You're going to have to develop something. It equalizes the kind of costs involved in litigation. The other major change with the marking law involved how you actually have to mark your products. Pre-AIA, you had to physically mark your products, or as close as you could get to it. If you couldn't, you know, if you're talking about a genetically modified crop, you're not going to have to stamp each and every little corn seed that you're dealing with. You can also mark the packaging, but you had to physically mark it. You had to physically put the marking and identify the patent number on the product. Post-AIA, they've gone to something where, well, first of all, you can still do physical marking. That is still allowed and it's still, you know, proper. But now they have something called virtual marking. And with virtual marking, what you can do is on your product, you no longer have to identify the particular patent numbers that are at issue. You can now put a website and say, to find the patents that are, you know, these are covered by, you know, patent or PAT, and then you can say these are covered by, and, you know, and you can go to this website. And you list the website, and you go to that website, and you can click on it. On that website, you can then identify the products that are covered by which particular patents. Now, you still have to identify the particular products. It's not just a matter of, you can't say, you know, have a website, link to that website. When you get there, just have a litany of patent numbers on that page and go, you might be covered by one of these. You can't say that. You have to identify the particular product and identify which patent is covered by it. So that's still a requirement, but it does open up the possibility, and it makes it a lot easier to update your patent marking. Because now, instead of having to go in and change the tool and die that you're using to stamp out this mechanical part, you can just go to the website and make a change in some code and plop, now you got your new patent number up there.
Hey, Jason.
Yep. Yep.
I think, so one thing that this raises in my mind, the whole marking issue and the expired patents raises this issue that is, in a sense, really ridiculous in the patent system. There was this problem that it was hard to change the die, but also it just turns out it's actually really hard to figure out if a patent is expired. In that right now we have this 20 years from the filing date, but it used to be 17 years from the filing date, and that's really what you would call a priority date. But that priority date doesn't apply if the original filing was a provisional, but it does apply if it was this separate type called a PCT application, and not if it was based on a foreign, but not on a foreign application. And then we also have these things called a patent term extension and also a patent term adjustment based upon different types of government delays. And then in addition, there's a possibility of a terminal disclaimer that might take away a term. And then we have these things called maintenance fees. Once you get a patent, you have to pay the maintenance fees, and if you fail to pay them, then the patent expires, except that it's really easy if you fail to pay that and abandon your application to revive it, right? And so all this process makes it really confusing for anybody to know whether any particular patent, and really, right, if you go to a patent attorney and say, here's a patent application, here's a patent, can you tell me whether this is enforced or not? They literally may say, well, it's going to cost you $1,000 to get to that answer, right? If they're really charging you and they really want to know the answer, right? And in some cases, it may take a lot more than that to know whether or not it's enforced or not.
Yeah, this is not a simple matter. The mismarking was not simply a matter of companies being lazy, that they just forgot to take these off or no one was monitoring it. Yeah, as Dennis said, it's a pretty complicated thing. And all of these different things that affect the term, it's not like you can go to one central database and find all, well, here's your patent, here's all the things that can affect terms, so you can calculate it all based off of that. They're all located in different places, they're all recorded different places, and some of them it's not recorded at all, some of them you're never gonna know publicly.
Jason,
yeah,
and I think another problem that companies have is that whenever they manufacture a product, this doesn't go to the expiration necessarily, but it goes to whether your patent still covers the product. You know, you get a patent on a bottle, and then next year I change the shape of the bottle a little bit. I reduce some of the plastic, make it a thinner bottle. I keep changing it, and year after year after year, and next thing you know, I've got my patent marking on there that I've had for 10 years, but 10 years down the road, is that still the same bottle? I mean, is this still covered by the patent claims? And so that's it's just another issue that companies are facing. Some of the suits were for expired patents. Some of the suits, you know, we've all had clients where they were sued because somebody said that you've mismarked your product. You've put a patent number on there where the claims don't cover the product. And so that's just kind of another avenue that these marking trolls really is what they were taking when they were coming after companies for damages under the marking.
Well, in the same vein, I mean, you could also have, if your patent was involved in litigation and the claims were construed, a court actually said what the claims mean, and suddenly that court construed the claims very differently than the way you were reading them. And now your claim scope has changed drastically, and a product that you were selling that was clearly covered by your patents before, now is not. And when did that take place? Is that as the date of the Markman order when it's issued? Is that when the claim scope changed? Is it when all of your appeals are exhausted? So again, the complication over that was, this got rid of all of it. Patent marking's dead. Patent mismarking is gone. There's no longer a suit for that, so you don't have to worry about it. One thing that I do want to mention is for this virtual marking with respect to pending patents. You now have the ability, if in the past, if you have a patent that is pending, you don't have any rights under that patent. Your rights only exist the moment the patent issues. Prior to that, you don't have any rights in the patent. You don't have any rights to exclude, as Kyle was talking about. But what you do have is you have these things called, there are some pre-issuance rights. If you give notice to someone about what your patent scope is, you give them actual notice, and then the patent later issues based on the claims, and the claims are identical to what you gave notice of, you can actually get some damages that cover the period of time from when you gave notice until when the patent issued. Now, they're limited to reasonable royalties, but you can get some patent damages for that period of time before the patent issues. Now, again, it's limited to where the claim scope is exactly the same as when you gave notice as to what issues, but you can do that. With virtual marking, it becomes a lot easier for you to add pending patent applications to your patent marking library. You also have the ability, because people are going to be clicking on a website, you can track potentially who's visiting your website. You can actually prove that your competitor, who you later sue, using their IP address, visited your website, viewed that particular patent application, viewed that particular claim scope, and you can show that you gave them actual notice and prove that in a court of law, enabling you to collect pre-issuance damages from the time when they took that notice to when the patent issued. That was never possible before. And proving actual notice, you know, having to deliver that, who was the notice given to, all of those things can be fairly complicated. This opens up a possibility of doing that, and throwing a pending patent application up on your website is easy. You can link to the actual application document if you want. You can put an image in there, and you can. It's really, really, really easy. This is something that I think companies should be taking advantage of more. I think this is something where this is a big change in the law that I think they can really take advantage of going forward. Any questions? Scott.
So I'm going to continue the litigation theme that Jason started here and talk about two new procedures at the Patent Office that we've never had before. We've never had anything like it, really, and there's not anything like it in Europe. And the two proceedings are a post-grant review and an inter-parties review. And this is not examination, this is litigation at the Patent Office. Both of these procedures are going to have complaint-type filings. You're going to have discovery periods. You're going to be able to take depositions in most instances. You have a right to a hearing in front of, we'll call them patent law judges. It's not heard in front of patent examiners. It's very, very far removed from patent examination. And there's two types here. And there's a certain strategy that if you have a client that's considering this, or you yourself are considering this, that you should think about when you're deciding whether to do a post-grant review or an inter-parties review. And it's based on the distinction between the two. First, a post-grant review is based on any ground of invalidity. So you heard Eric and Jason and Kyle, they all talked about what was invalidating prior art. You heard patents and printed publications. Well, there's other roads you can go down to invalidate a patent. You can look at the document itself. You can look at the claims and say, you know what, this is indefinite. It doesn't enable. You heard enablement, which means it doesn't tell you how to practice the invention. There's a written description requirement that says basically you have to set forth what your invention claims. There's all these things that are grounds other than relying on a document that says, aha, this discloses everything in your invention, it's invalid. So you can go down all those roads in a post-grant review. You have to do it within 9 months after issuance. That's a big key. This, though, from a litigation perspective, for both inter-parties review and post-grant review is the best part of this. Preponderance of the evidence standard for invalidation. Right now, when Jason and we go to court and we're in front of a jury and we have to invalidate a patent, it's not preponderance of the evidence. It's clear and convincing, which that's a standard that's ratcheted up here. Preponderance of the evidence is down here. More likely than not, 51%, 52%, who knows. But it's not clear and convincing. And so this is a very big deal. In practice, what this means is, if your ducks are in a row, you can go to the patent office and you have an easier, lower hurdle to jump over to invalidate a patent. This is why you don't go to the patent office with post-grant review, and it's the estoppel provision. There's an estoppel provision that applies to both inter-parties and post-grant review, and it applies to all arguments you raised or could have raised. And that's a very big deal. So, if I'm in a post-grant review period when basically every single road of invalidity is available to me, I think I've got to go down every single road of invalidity, because if I lose in that post-grant review, I'm barred from raising any invalidity defense to that patent again. And so this would come up in the following context. Say somebody has accused me, or I see a patent that issues from a post-grant review context. And I'm really worried about it. I've been monitoring this application. I've got products that are out there. It just came out from the patent office, and I think it reads on my products, but I've got some good invalidating art. So I can go file, and the person that got the patent is drugged into litigation-style proceedings in the patent office. Involuntarily, they've got to go. Now, if I lose, that person can take me to federal court, sue me for infringement, and if I've instituted a post-grant review, they're going to have a very good argument that I don't have a single invalidity defense. Not one. Now I'm going to try to squirm and say, well, you know, I didn't know about this, so it's not an argument I raised or could have raised, but that's a very real danger when you institute a post-grant review, which is within that 9-month window. And now the second one that you can think about is an inter-parties review. And this replaces inter-parties re-exam. This is based only on patents or printed publications. And you can do it any time after the 9-month period expires. All right, so here I cannot raise my written description, my enablement arguments. I'm relying strictly on 102, 103 type grounds. What that means is I'm relying on a piece of paper that says, hey, this discloses everything that's in that invention, or the combination of these two pieces of papers makes that obvious. So,
question.
Yes, sir.
On your second one, it's still preponderance of the evidence, though?
Yes.
So it's still the lower bar?
Same standard for both, lower bar for both. And so the question then is, well, when should I do one versus the other? Or what's the best strategy for doing that? And my recommendation, and I'm interested to hear what the panel's recommendation is on this, is you have to evaluate your prior art. You have to think about what your best defenses are. If you think your best defense to invalidating this thing is going to be a patent or a printed publication, it seems like it would be reasonable to wait after that 9-month period expired, because if you lose on that, you can still go to federal court and you can rely on a written description defense, an enablement defense. You still have time to develop other defenses that are not based, invalidity defenses that are not based on that patent or printed publication. If you think you've got great patent and printed publication type invalidity defenses, plus everything else that we discussed, enablement, written description, then maybe you do want to go post-grant review and essentially what I'll call scorch the earth of invalidity at the patent office.
It's very much, though, if you're going to take a shot at the king in the post-grant review, you better kill him.
Right.
Because, yeah, you're in real trouble if you don't.
This is kind of how I explain it to clients when we're making this decision. The patent office is in the business of issuing patents. District court judges are not. The best place historically to have my invalidity challenges of any type is in a district court.
But now here's the kicker. When you lose at the patent office, you go to the federal circuit under the lower standard. So that helps.
You appealed.
And
Right.
this is going to change that calculus because of the change in the standard, that's for sure.
When you lose at the trial court, you go to the federal circuit, which is the specialized court that hears all of the patent appeals from across the country, no matter what district court you were in. Same with this. The federal circuit will hear those appeals, and they'll hear it under that lower standard, which I think is a big plus. One of the things that just recently happened with these post-grant review proceedings, the patent office is still kind of hammering out not the fee structure anymore, but rules for it. Is it going to operate kind of under a federal rules of civil procedure type machinery? Or how exactly are we going to do it? What's the timing? I think a lot of people are skeptical that the patent office is going to actually have the manpower to get into a lot of this. I mean, what if I have a discovery dispute during one of the post-grant review, the inter-parties review? Is there going to be a motion practice? How is it resolved? Do you have special judges to hear the motion practice? And are these motions brought under the federal rules of evidence, civil procedure? I mean, there is a hornet's nest of issues there. And so when these things start getting filed, to the extent they will, is the patent office going to have the manpower to do it? Right now they're behind on patent prosecution. There's kind of a little bit of a lag. You can pay for new expedited type proceedings at the patent office, but those are examiners. Are they going to be able to hire enough judges to handle all this? Who knows? Is the price tag going to be a deterrent for companies doing this? The proposed filing fee for a post-grant review, this is just the filing fee, $38,500, and that's if you're challenging between 1 and 20 claims. That's pretty steep. If you go up to, I think the next rung is 20 to 30 claims or 20 to 40 claims, it adds additional price, it adds an additional, I think $5,000 or $2,500 onto that, and it keeps going up from there. And it's challenge claims, not claims in the patent. So essentially, the more claims that are at stake, the higher your filing fee is going to be, not to mention the attorney time you have to spend getting everything prepared, doing your investigation, and then actually litigating it. I'm curious to hear from some of the prosecution practitioners here about what their expectations were, because from what I understand, talking with my colleagues and others, is that whenever this post-grant review especially was coming out, they were kind of hoping that it would be more like a European opposition practice, and it's not. I mean, it's taking litigation to the patent office. I think, and Professor Crouch may be able to comment on this, what they were thinking was that let's kind of alleviate some of the burden maybe on the federal courts. Let's get rid of a lot of maybe frivolous lawsuits or lawsuits filed by patent trolls or license acquisition companies or NPEs or whatever you want to call them. However, I don't know of anybody that's going to be able to challenge a patent troll on a post-grant review. I mean, when you see those patents in litigation, they're patents that are 6 years old, that claim priority going back 15 years. I mean, they're not new patents that your clients get sued on from Acacia. So I doubt this will ever apply to any non-practicing entity, just giving the timing.
Before you move on, can you just mention what's in the bottom of your slide there? I think the effective date is an important thing to keep in mind.
Oh, sure. So there's an effective date, and then there's what I'll call the reality date. The statute says that these provisions, the post-grant review and inter-parties review, are going to be effective 1 year after September 16th. However, they only apply to applications that are filed on or after March 16th, 2013. So the earliest you're going to see any of this is if, let's say, you file an application on March 16th, 2013, you pay for the fastest race through the patent office you can get, and it's going to be a year later. So middle of the year 2014 maybe is when you're going to start seeing some of these. And that's, again, assuming we get all the rulemaking and the machinery straightened out.
Yes. What would you think, I mean, what is this directed to as far as a real-world situation? In what real-world situations do you see this being applicable to?
Large company, high-stakes patents. Drug companies that monitor their competitors 5 different ways, who have products that they've thrown out on the market, but their competitors have got patents that have been sitting in prosecution for years. They filed requests for continued examination, so that now you've got a prosecutor, a good one like Eric, who can sit down and say, all right, I see your product out there. Now I'm going to draft claims to read right on that product. You've had your product on the market for 2 years. It sells $1 billion. Next thing you know, your competitor's patent shoots out from the patent office. That's a big problem for you, especially if they move for an injunction. There's problems with that, but it's just a huge problem for you. And so before that happens, you can do your investigation, you can do your invalidity study, you can get on top of that patent and application before it issues and be ready to go if your competitor is going to challenge you. I mean, I don't think this is going to be applicable to universities. Be tough to recommend it. I don't know if any client in litigation, kind of traditional litigation, other than big budget, large corporation, multi-million, maybe even billion-dollar stakes litigation would engage in this.
I mean, I think the only other thing I can think of is if you've got a client who they can't afford litigation, full-blown litigation, it's a gamble, a huge. I mean, it's about the company gamble, but you could take your shot here, which will be cheaper than federal court litigation.
But we don't know how much cheaper.
No, exactly, and that's still yet to be determined. But I think it was envisioned to be an alternative to litigation that would be cheaper. It's not working out that way.
Right. Yeah, I don't see
it. It's not the European opposition that we were talking about. So it's kind of, I don't know where it's going to be applicable. I can maybe see that as being a huge gamble if you wanted to take it.
There's one other for companies that do more strategic planning about their product placement, that is thinking about moving in a certain direction, but they see that there are a couple of key patents that would prevent them from moving into that market. Right? They could go ahead, and this essentially serves the purpose of what we might call a declaratory judgment action. But if they're thinking of moving to the market area, they wouldn't yet have any standing in court to actually file a court case, but they would have standing to file this. Right? And there was also a lot of hope that there have been a lot of action of public interest groups, who such as the AARP and this entity called PubPat that has been trying to go after patents to essentially reduce the cost of drugs. But I think that it's likely that this $35,000 or $40,000 filing fee may be cost prohibitive for those entities to get into this game.
A lot of it depends on what discovery rules they give. The big thing that costs money in litigation is all the discovery that takes place. So if your invalidity defense is based on a piece of prior art that you found, you're probably okay going this direction, even if the discovery rules are limited. If, however, it's based on their prior activities, if they had some commercial activities that you have to prove up, you're going to want the full federal rules of civil procedure to get all the discovery you can from them, because you're going to have to get the evidence from them to prove that the patent's invalid.
Now, those are excellent points, and here's a frustrating point. If you're the person that's hauled into a post-grant review or an inter-parties review, and you're the patentee essentially, you're on defense. I mean, you're going to the patent office to essentially get beat up. Your patent's going to get beat up. You're not putting on your infringement evidence. You're not putting on evidence of damages. I mean, you're literally going and you're on your heels taking punches. It's not like when you're in court, you get your case and he gets his case. and at the end of the day, you've got infringement, invalidity, non-infringement. This is all defense if you're the patent owner. So maybe that would make it a little bit cheaper because you don't have damages evidence, you don't have the other evidence of infringement, non-infringement, but it's still going to be expensive. Still going to be expensive. Your slightly cheaper alternative is the inter-parties review with a filing fee of $27,200 for 1 to 20 challenge claims. This is the one that's based on patents and printed publications, but it's also available anytime after that 9-month period expires, with a few exceptions. This time limit here about litigation. If you're sued, you've got to do this within 12 months of litigation. If you file a DJ, you can't do it. Same with a post-grant review. If you file a DJ, you can't do it. And a DJ, declaratory judgment, is where you can essentially file a lawsuit in federal court if you're threatened with a patent to say that that's invalid. The patent's invalid. The discovery here, the rules so far read like it's going to be a little more limited than a post-grant review, but we still really don't know yet. Still right to a hearing, again, still the lower threshold for proving invalidity. But again, the key to this one is the patents and printed publications and the limited effect, the potential limited effect of the estoppel based on that. So again, if that's really your great invalidity evidence, I would consider waiting till an inter-parties review. That way you can argue later if you are hailed into court somewhere that, look, the estoppel only applies to the patents and printed publications that I had available to me, and I've got all these other indefiniteness arguments, written description arguments, enablement arguments, et cetera, that make this patent invalid. This one, unlike the post-grant review, this might get shoved back at a license acquisition company. It's $27,200. Typically, when patent trolls, NPEs, they sue somebody, their objective is to get from point A to point B as quickly as possible and as cheap as possible. They don't want to spend any money, which is why they file one lawsuit, they used to, and lump 60 defendants together. They churn out discovery, kind of cookie-cutter, one-size-fits-all discovery for all these defendants. So that's one cost for the patent troll. Each defendant has to pay their attorney to answer unique sets of discovery requests that are applicable only to that defendant. So you start multiplying attorney costs and costs of litigation, and it would get out of control, and eventually the companies would say, uncle. With this one, perhaps I could see a company that would say, you know what, rather than get lumped into discovery, let's put them in inter-parties review, take out the infringement actions, and just attack the validity of this patent. 1 to 20 challenged claims. A lot of times, patent license acquisitions companies, they don't just assert one claim. They'll assert 30 claims, 40 claims, if they've got the patent to do it. So that could make this a little bit challenging. It'll ratchet up the fee, but it could also complicate the proceedings in an inter-parties review. But again, none of these were in effect prior to the AIA. You couldn't go to the patent office and essentially do litigation. What you had available before you was an ex parte re-exam, which you still have. You had an inter-parties re-exam, which is dead. And now you've got ex parte re-exam, you've got post-grant review, and you've got inter-parties review. Somebody have any questions? All right, turn it over to Professor Crouch.
Yeah. So, well, I think I'm here on campus over in the law school. If anybody wants to ever come and talk about patent law, feel free to come by. I think I'm going to cede my time to lunch, which is just about to start now. But we should thank this panel for doing a great job.
Okay, well, thank you everyone for coming out. If we have any questions, we're happy to stick around. If you want to go get lunch, we certainly won't be offended if you get up and walk around. I'm happy to stick around. I'm sure the other panelists are. Just hang around just for a few minutes if you have any questions. Otherwise, we're of course open the floor to questions as well. But if you do want to go eat lunch, we won't be offended if you choose lunch over us.
Thanks for choosing us over the Astros.
Yeah.
Thank you.